Georgia has a landlord-friendly late fee framework with minimal state-level regulation, giving landlords broad discretion while still requiring basic reasonableness. The governing law is found in Georgia Code Title 44, Chapter 7, which covers landlord and tenant relations, along with general contract principles. If you're a landlord or tenant in Georgia, the state provides limited statutory guidance on late fees, and the lease governs most of the details. Let's start with the basics. Georgia does not impose a specific statutory dollar cap or percentage cap on late fees. There is no statute that limits the fee to a certain amount or percentage of rent. The fee is governed by the lease terms and general contract principles. Georgia does not mandate a grace period by statute. There is no state law requiring a specific number of days before a late fee can be charged. If your lease says rent is due on the 1st and a late fee applies on the 2nd, that's enforceable. However, standard practice among Georgia landlords is to include a grace period of 3 to 5 days, and many property management companies use 5 days as the default. The key legal principle is reasonableness under Georgia contract law. A late fee is a liquidated damages provision, and Georgia courts have a well-developed body of law on liquidated damages. Under Georgia Code, Section 13.6.7, a liquidated damages provision is enforceable if the damages from the breach are difficult to calculate at the time the contract is formed and the amount fixed is a reasonable estimate of the probable loss. If the amount is clearly disproportionate to the actual damages, the provision is an unenforceable penalty. Georgia courts have generally been business-friendly in evaluating liquidated damages provisions, but this friendliness has limits. A late fee that roughly corresponds to the landlord's actual administrative costs from the late payment is easily enforceable. A fee that dramatically exceeds those costs, functioning as a profit center rather than cost recovery, crosses the line into penalty territory. What's reasonable in Georgia? The state has a wide range of rental markets, from expensive Atlanta neighborhoods to very affordable rural communities. A flat fee of $25 to $75 or a percentage-based fee of 5 to 10% of the monthly rent is generally defensible. In Atlanta, where rents commonly range from $1,300 to $2,200, a fee of $65 to $100 is typical. In more affordable communities, lower dollar amounts are appropriate. The lease must clearly state the late fee terms. Georgia courts expect clear written agreement. The lease should specify the rent due date, any grace period, the exact fee amount or formula, when the fee triggers, whether additional charges apply for continued non-payment, and whether the fee is defined as additional rent. Oral arrangements about late fees are difficult to enforce. Georgia's Fair Business Practices Act, found in Georgia Code Title 10, Chapter 1, Part 3, prohibits unfair or deceptive business practices. While the act primarily targets consumer transactions, it can apply to residential rental practices in certain circumstances. Systematic overcharging of late fees, particularly combined with misleading lease provisions, could be challenged under this framework. The act provides for actual damages, injunctive relief, and attorney's fees. Compounding late fees in Georgia must satisfy the liquidated damages standard. A single one-time fee after the grace period is the simplest approach. If your lease includes daily or weekly charges, the total must remain reasonable under Section 13.6.7. A compounding structure that could produce fees exceeding 15 to 20% of the monthly rent within a few weeks would likely be struck down as a penalty. Most Georgia landlords use a single flat fee. The interaction between late fees and the eviction process in Georgia is governed by the dispossessory proceedings statutes. Georgia Code, Title 44, Chapter 7, Article 3. Georgia does not require a pre-filing notice period for non-payment. The landlord can file a dispossessory affidavit and summons immediately upon non-payment. This makes Georgia's eviction initiation one of the fastest in the country. The dispossessory summons demands the tenant either pay or vacate within 7 days. The amount demanded must be accurate, including only unpaid rent and any compliant late fees. Whether late fees are included depends on the lease. If defined as additional rent, they're includable. Georgia's fast dispossessory process means that late fee disputes and eviction proceedings can overlap almost immediately. An inflated demand that includes non-compliant fees gives the tenant grounds to challenge in the answer, which can result in a contested hearing rather than a default judgment. Getting the fee calculation right from the start keeps the process efficient. If the tenant answers and contests the eviction, the case proceeds to a hearing in magistrate court. Georgia magistrate court judges handle a high volume of dispossessory cases, particularly in Fulton County, DeKalb County, and Gwinnett County, and are experienced with late fee disputes. Georgia does not impose a statutory cap on security deposits. The deposit amount is governed by the lease. However, for landlords with more than 10 units, or who use a property management company, the deposit must be held in an escrow account, and the landlord must provide the tenant with written notice of the account location. The deposit must be returned within 30 days with an itemized statement of deductions. Unpaid late fees can be deducted if the lease authorizes it and the fees are reasonable. For landlords with fewer than 10 units who don't use a management company, the escrow account requirement doesn't apply, but the 30-day return timeline and itemization requirements still do. Failure to return the deposit within 30 days can result in the landlord being liable for up to 3 times the amount wrongfully withheld. Georgia's treble damages provision for wrongful deposit withholding creates significant risk. Deducting excessive late fees from the deposit can trigger the 3 times penalty. A $75 excess deduction becomes $225 in liability. Clean late fee calculations at move-out are essential. For tenants receiving housing choice voucher assistance, common in Atlanta, Augusta, Savannah, and other Georgia cities, landlords should not charge late fees when the housing authority's portion is delayed due to processing. The tenant cannot control the authority's payment timeline. If the tenant's portion is paid on time, the fee should apply only when the tenant's own payment is actually late. Georgia's military population is significant, centered around Fort Moore near Columbus, Fort Stewart and Hunter Army Airfield near Hinesville and Savannah, Robins Air Force Base near Warner Robins, Moody Air Force Base near Valdosta, Kings Bay Naval Submarine Base near St. Mary's, and Marine Corps Logistics Base, Albany. Fort Moore, formerly Fort Benning, is one of the largest Army installations in the country, generating massive rental demand in the Columbus and Phoenix City corridor. Fort Stewart and Hunter generate significant demand in the Hinesville, Richmond Hill, and Savannah areas. Robins AFB generates demand in Warner Robins and the Middle Georgia corridor. Military pay is predictable, and most military tenants pay reliably. Fort Moore's training mission produces constant rotation. New military tenants arrive regularly and may need time to establish direct deposit. Some Columbus landlords accommodate first-month timing while setting clear expectations going forward. From a practical standpoint, Georgia's rental market is dominated by the Atlanta metro, one of the largest and fastest growing in the country. Atlanta is the state's dominant market with enormous geographic spread. The economy is driven by logistics. Hartsfield-Jackson is the world's busiest airport. Healthcare, including Emory Healthcare, Piedmont Healthcare, and Grady Memorial, corporate headquarters, Coca-Cola, Delta Airlines, UPS, Home Depot, Southern Company, technology, entertainment, and education. Rents vary dramatically across the metro, from $2,200 in Buckhead and Midtown to $800 in many South and West Side communities. Most Atlanta landlords charge flat fees of $50 to $75 with a 5-day grace period. The professional tenant base in Midtown, Buckhead, and the suburban office corridors generally pays on time. Late fee enforcement in premium neighborhoods is limited to a small percentage of tenants. The Atlanta suburbs, Marietta, Roswell, Alpharetta, Johns Creek, Dunwoody in the north, Decatur, Tucker, Stone Mountain in the east, Kennesaw, Smyrna, Vinings in the northwest, have strong markets with varying dynamics. North Fulton and East Cobb have premium rents and professional tenants. South Fulton and Clayton County have more affordable rents and higher late payment rates. Savannah has a growing market driven by tourism. The Port of Savannah, one of the fastest-growing ports in the country, Fort Stewart, SCAD, and healthcare. The combination of military demand, port-related employment, and tourism creates a diverse tenant base. Augusta has a moderate market driven by healthcare, including the Medical College of Georgia and Augusta University, military, Fort Eisenhower, formerly Fort Gordon, and manufacturing. Columbus has a heavily military-influenced market adjacent to Fort Moore. Athens, home to the University of Georgia, has a tight student market. Macon has a moderate market driven by healthcare and Robbins AFB proximity. Warner Robins has a military-dominated market. Valdosta, near Moody AFB, has a military-influenced market. Albany and Hinesville have markets heavily dependent on military demand. Statesboro, home to Georgia Southern, has a student market. One best practice for Georgia landlords: set your late fee at a level that satisfies Section 13(6)(7)'s liquidated damages standard. Document your actual costs and set the fee in that range. In Atlanta, where rents range widely, a percentage-based fee of 5 to 8% automatically scales to the rent level. A flat fee should be calibrated to the specific market. Another best practice: include a grace period of at least 5 days, even though Georgia doesn't mandate one. 5 days is industry standard across the Atlanta metro and most Georgia communities. The grace period prevents disputes and demonstrates good faith. A third best practice: pay careful attention to late fee calculations in dispossessory proceedings. Georgia's fast eviction process is a powerful tool, but only if the amount demanded is accurate. Including non-compliant late fees in the dispossessory summons invites a contested hearing. Calculate carefully, include only compliant fees, and present a clean filing. In the high-volume magistrate courts of Fulton, DeKalb, and Gwinnett counties, a clean filing typically produces a clean result. For the complete guide to Georgia late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.